Good afternoon. As Taylor said, my name is Daniel Gvertz. I'm a partner here at Tully Rinckey. We're going to be talking today about child custody relocation cases. And given the nature of, what I do for a living and what these cases are like, these are always very challenging. There's always a lot going on. There's a lot of emotion involved. When you're talking about your children, you're not thinking about, spending almost zero time with them. What I always have to tell people when we're talking about relocation, there are only really two, there's really only two possible outcomes, right? It's the school year in one place and the summer vacation and long school breaks with the other parent. And that's a lot of time to go without seeing your child. So when we're talking about a custody order, there are only two ways to create one. It's either by agreement or with a judge ordering it after a trial. It's very hard to think of a situation where you'll agree that you're only going to see your child for, 8 weeks of a summer break and a couple of week-long vacations during the school year. This is not simple. There are a lot of considerations that go into this, and there is so much discretion being held by the courts that, as sort of a precursor to what I'm going to talk about, so much discretion is held by the courts that we can't even guarantee that if you meet all of these factors, this is something that is going to produce a positive result for you. All of that said, I've been practicing law for nearly 15 years. I specialize in the practice of family and matrimonial law. This is what I do. And if you have any questions, as Taylor said, you can put them in the chat. And at the end, you'll see our contact information so you can reach out to us and schedule a consultation if that is something that you would like to do. So the controlling case here that courts will look to determine the factors is called Tropea versus Tropea. It was decided in 1996. And that is the case that defined the factors that are considered for a child relocation case from one jurisdiction to another. The factors that a court will consider is each parent's reason for seeking or opposing the move, the impact that the move will have on the quantity and quality of the child's future contact with the non-custodial parent, the quality of the relationships that already existed between the child and both parents, and the degree to which the custodial parent's life and the child's life may be enhanced by the move. There are other factors that courts will consider, and the controlling factor that courts always consider in every custody case is what is in the best interests of the child. And each of these factors, though it has a definition, each of these factors essentially comes down to what is in the best interests of the child here. And the way that we'll go through this is I'll go through the way that we would argue in favor of and the way that we would argue against any potential move. So courts consider, with regard to the reasons for the relocation, employment opportunities, which is relevant when we're talking about a new opportunity that will substantially improve the life and opportunities for the child. So if you're living in one area and you get just an absolutely amazing job offer across the country, if you can show demonstrably that taking that job opportunity is something that will improve not just your own life, but the child's life, that is something that the court wants to take into consideration. If we're talking about just the lateral move or, even a downgrade in what your position is, courts will take that into consideration as to why it is you're looking to uproot the child, move to another jurisdiction, and decrease the amount of time that the child's going to spend with the other parent. Another factor is educational prospects, which is relevant where the child has educational or medical needs that can only be better met in a new location. In order to argue on that factor, you have to have those things set up, and that's not easy because we're talking about having, a doctor or a school or something like that set up before you even move, before you even know if you can move. And that's something that I should have said at the start here. while you can certainly petition the court to move a child from one jurisdiction to another after you've already moved, it's a lot simpler to do it beforehand, to sort of ask the court's permission before you move. But while that's simpler in a legal aspect, it's certainly not simpler practically speaking, because if you don't know whether or not you're going to move, how can you set up a job? How can you set up a school? How can you set up a pediatrician? How can you set up any of this for a child before you actually move? That's why these situations are so fraught with acrimonious litigation, where we're not likely to get any kind of agreement, and we're not likely to get any real and true easy way to figure out what's going to happen, because you don't even know if you're going to be able to set up a new job before you know whether or not you're going to be able to bring your child. You don't even know what kind of residence you're going to need before you know whether or not you're going to be able to bring your child. These are not simple questions, and they are not questions with simple answers. Family support is something else that courts will look into, which is relevant when there's a support system that the child has in the current location that maybe is insufficient to meet the needs of the child, and there's more or better family support in the new location. I actually just had a case earlier today where I was talking to someone who lives in the state of Washington, and they have family in the state of Washington, and their ex-spouse also has family in the state of Washington, but for some reason, the ex-spouse moved to Hamburg, New York, across the country, and they moved with the child. And so that's something that a court will take into account to say, sure, time with the one party will be diminished because we're moving the child, we're going to attempt to move the child from Hamburg all the way to the state of Washington, but the non-custodial parent's family is in the state of Washington. So there's a support system there. And while we're diminishing one parent's time with the child, we're increasing the amount of time that that child is able to see their extended family. And that's something that a court will take into consideration. It's not one of the more important, one of the heavier factors that a court would consider. Arguing against a move, unsubstantiated reasons. If it's impossible to put into words the reason why one wants to move, then a court will take that into consideration and say that we're not going to move the child from one jurisdiction to another because you can't even say why it is you want to move. There's also lack of legitimate need, which is pretty much the same. It was interesting going through cases where courts would identify these different things. Lack of legitimate need, just if there are no benefits to the child from moving from one place to another. There's no medical needs, there are no educational needs that the child has that require, some kind of dramatic move that you can prove. And then in the middle, there's avoidance of legal obligations. If the court believes that the reason for the move is to something like avoid paying child support or to get away from the results of another, most of the time, criminal case in the current jurisdiction. And what that means is, different states have different requirements for child support. Different states have, I know that in the state of Ohio, they will have child support be proportional to the amount of time that you're spending with the child. So if you're trying to move the jurisdiction to Ohio or another state with something similar to that, a court will look at that and say, well, it looks like you're just trying to move in order to avoid having to pay child support. And judges absolutely hate that. They will not, that will absolutely be something that stops a relocation in that case. But the most important thing to consider when we're talking about the reason for the relocation is making sure, again, as I said at the top, and it will be a continuing theme throughout, that the reason for the relocation is in the best interest of the child and not the best interest of the parent. For as much as it's important for you to live your own life and do the things that improve your life, courts are looking at what is in the best interest of the children that are involved in this. And if you can't show with the legal standard that they have is called a preponderance of the evidence, if you can't demonstrably show in really paperwork why it is that moving is more important than not moving is better for the children than not moving, then you're not going to be able to get a court to side with you on this. The next factor that courts will consider is the impact on the child's relationship with the non-custodial parent. And this is where most relocation cases will fail. When you're talking about the impact on the non-custodial parent, there is no way to minimize that. As I said at the top, generally speaking, what we're talking about is trying to have the children in one location for an entire school year, which generally goes anywhere from August to June, August to May, September to June, something like that, with a couple of weeks in the summer and a couple of long vacations during the school year to the other parent. When you're going from, maybe a 50-50 visitation schedule down to, 1 week in November, 1 week in December, 1 week in February, and 6 weeks in the summer, that is a massive change. And judges will look at that and say, you are choosing to move. You are choosing to remove yourself from the jurisdiction. That does not give you the right to remove the child from the other parent who has been, presumably, a consistent presence in the child's life. So things that the courts will look at in favor of meeting this factor are improved visitation schedules. You can explore how modern technology and creative visitation schedules can mitigate the impact of the distance. If there are things that we can do, that we can find, that will show that, sure, we're moving across the country, but we have family, in between. We constantly visited in between, right? If there's somewhere that as a family you constantly went to, or you had family nearby, that's something that we can use to say, sure, we're decreasing the visitation, but it's not just going to be the long school vacations. It's not just going to be the summer vacation. There's going to be 3-day weekends where we were constantly somewhere, and the other parent can come and see them during that time. If we can figure things like that out, that's something that a court will look into. You have to establish how the non-custodial parent will continue to have meaningful access. But again, even with that meaningful access, there's still the need to weigh the loss of the total amount of time that the non-custodial parent has with the child or the children. One of the things that has really come on recently is technology for maintaining contact. Just 10 to 15 years ago, we didn't have things like FaceTime and Teams meeting and WebEx meetings where you all can see my face and we can have a real discussion right now. And obviously, when we're talking about very young children, that's not super helpful, but teenagers are on their phones all the time now. So we can talk about a situation where the teenage children have, their own phones and their own methods of having video contact, and we can schedule that and make sure that it's something that is kept up with. And if it's something that we can demonstrate to the court provides meaningful access, which is a thing that, courts will be looking for, if we can just, if we can show demonstrably that there's meaningful access with the children, then that's something that a court will look at and say, okay, maybe the impact on the non-custodial parent's time with the child or children isn't something that's going to be as negatively affected as it looks when we're talking about moving from one place to another and, going from a 50-50 visitation down to just a few weeks in the summer. And as I mentioned earlier, proximity to extended family. If you happen to be moving somewhere where, your parents are from, or your cousins, aunts, uncles, and really the a key way to do this is if you're going somewhere where you had previously lived with the child, or where the non-custodial parent has family also, you can use that as an argument under this factor to talk about, that we're increasing the ability for the child or children to have a relationship with the non-custodial parent's extended family, or with your extended family, people that the child or children had an existing relationship with that, fell off because you lived in a different place, and you're sort of rekindling and reigniting that. Arguments against this are significant distance that reduce visitation. And that's when we're talking about, moving like across the country. If we're only talking about moving from, New York to New Jersey, right? That's only a several hour long drive. We're not talking about something that makes it impossible to see the children. But a larger move obviously is going to require more scrutiny from the court and more, more argument on that issue. And then there's the issue of potential estrangement. There, in this factor especially, courts want to know if one parent has a history of attempting to separate the child or children from the other parent. And is this move another method of doing that? Is this move, something that a parent is trying to use to remove the children from the other parent? And why, right? One of the issues, again, we're talking about the best interest of the children throughout all of this. It is generally speaking within the best interest of the children to have a full relationship with their parents. So if you're using this as a reason to, or if the other party is using this as a reason to specifically remove the children from the other parent, courts will take that into consideration and they will not look upon that very favorably. The next factor that courts consider is the existing relationship between the child and the custodial and non-custodial parents. And this is the more traditional sort of best interest analysis that a court looks into in every sort of custody and visitation case. And so in order to weigh this, courts consider which parent has generally been primarily responsible for the care of the child, which parent has, prior to the move, spent the most time with the child. Has the parent with primary responsibility been active in involving the non-custodial parent? And what level of involvement has the non-custodial parent had or attempted to have? This is one of the biggest arguments that I wind up having sometimes with my own clients and certainly in court. It is the responsibility of the parent with primary placement. It is their responsibility to make sure that the non-custodial parent has meaningful access with the child or children. And what does that mean? That means making sure that even though you have primary responsibility with the primary placement with the children, it is your responsibility to make sure that the children see the other parent. And if you're not acting in a way that increases or places an emphasis on meaningful visitation and meaningful time with the other parent, courts are going to look at that and say that you are the reason why the other parent doesn't have meaningful access. And so the existing relationship is exactly what it sounds like, right? What are you doing with the children? What are you, who's responsible for scheduling pediatrician appointments? Who's responsible for getting them to and from school? Who's responsible for making sure that all the homework gets done, right? These are the basic arguments that we wind up having on every custody and visitation case, but it's one of the factors that a court will consider in terms of relocation, as well as, why it is that the relationship isn't what you claim that it could be. And the last factor that's outlined in the Tropea case is the degree to which the child's social and educational opportunities may be enhanced by the move. So this is where we start talking about access to better schools, better extracurricular activities, if there are medical concerns, if God forbid somebody's child has a medical condition, if there is a medical facility in a certain place that is better than the ones where you are locally, that's where this is the factor that courts will use to make that consideration. Arguments against that are disruption of existing social networks, loss of community ties, and adjustment issues. Adjustment issues are again, where you're talking about children with certain needs that will have a hard time getting used to what it is that, a new place, a new situation. And one of the things that I've noticed in my practice when we talk about disruption of existing social networks, when we're talking about older children who are maybe, juniors and seniors in high school, if they're on, school teams and school clubs, right? And they've worked their whole lives, right? Their whole high school career to get to, to be the starting quarterback of the high school team. And if they move from, you know, Buffalo, New York, across the country to San Francisco, California, they're not going to be able to just walk in and be, you know, the starting quarterback of a team. And I have heard judges specifically take that factor into consideration and say, we can't move this child. It would be fundamentally unfair to take a child who has worked their whole life to be, you know, the starting quarterback of a team in Buffalo, New York, and move them somewhere where they're just going to be just another kid in school. And courts will take that into consideration. And so you have to make sure that you have taken that into consideration when you're going to move, which of course you have, because you're a good parent. But and that's why these are factors to consider and things to think about, right? Not one of these is something that just decides, right? It's not just something that flips a switch and says, okay, now this is the factor that that makes the decision easier for everybody. This is just one of many things that a court takes into consideration. And when we're talking about social networks and community ties, we're also talking about the children's friends and the family that exists there in the original jurisdiction where we're talking about moving the child away from. And that's why when you're talking about trying to move, you have to try to set up as many of these things as possible. Again, practically speaking, that's not easy, but that's why these arguments tend to become as acrimonious as they are. There are other factors that courts will take into account outside of the Tropea factors that are specifically listed in that court case. One of them is the custodial parent's ability to meet the child's needs in the new location. This is pretty similar to what I had talked about earlier in terms of medical and educational facilities, but enhanced resources, right? We need to figure out how the move will enable the custodial parent to better meet the child's needs, whether financially or emotionally. And that could go back to a new job. It could also go back to, this is where we start talking about the relationship that the two parents have. If one parent has a history of family offenses against the other, stalking, harassment, things like that, if that's something that exists in the relationship, then improving that parent's life emotionally necessarily improves the children's lives. So that's where the court will take that into consideration. Financial stability, right? Improved financial circumstances in the new location. Again, if we're talking about a new job where your income's going to increase to 300%, that obviously will provide a better life for the children. Of course, the court has to take everything into account, right? It's not just I got a much better job, therefore the children are going to be better off there, but it is definitely something that the court takes into account. On the other hand, right, on the flip side of that, if there's an uncertain financial situation, I have had people tell me that they want to leave the Western New York region specifically just because they don't like it here and there aren't any opportunities here. So they want to go somewhere where they have heard there are more financial opportunities, more better employment opportunities. That's an uncertain financial situation. You're not guaranteed anything if you just move from one place to another. So if you're arguing against a relocation, that could be a factor in there if the other person doesn't have any plan for what it is that they're doing. And same in terms of a lack of local support, right? If you're moving to a place that you've never lived, you don't have any family, you don't have any friends, right? If that's where someone is trying to move the children, courts will take that into consideration and say, well, there's no support network there. There's nobody there. And that's not something that's going to be in the children's best interest. And the same is true of difficulty accessing services. Courts will say, look, the child has certain needs, occupational or physical therapy, and you are trying to move them to a rural district somewhere in the middle of the country. Well, they don't have, easily accessible physical therapy centers there. So again, that seems kind of obvious when you put words to it, but these are all things that I've pulled from my own practice. So, there are people who say, you know, we need to move to a certain area, but the nearest doctor's office is 3 hours away. That's something that a court will take into consideration when determining whether or not to allow a parent to move with the children. There's also the stability of the new living environment, right? It is important to have an established and secure living arrangement in the new place. You can't move somewhere and take your children with you into temporary housing. That is something that courts will look at and almost uniformly say that is something that we're not going to allow the children to be moved into. In terms of the same is true of a secure job and a stable community. This is where you make arguments about what the neighborhood is like, what the living situation is going to be like. And again, going back to what I said at the start, where you don't get a lot of agreement on this. So because you don't get a lot of agreement, we don't get a lot of stipulations, you wind up having to go to trial on these kinds of issues. These are the factors that you can argue to say the children either should or should not move because the person moving is trying to move into temporary housing. They don't have family there. They don't have friends there. They don't have a place to live there. So we need to keep them, keep the children here where they have, guaranteed long-term housing. So those are the factors that I generally see courts consider. And of course, in addition to all of that, the courts are very consistent in terms of any attempt to move jurisdiction with the children has to be weighed on its own. And the guiding principle, as I've said throughout, is what is in the best interests of the children. So what do we need to do in order to get a court to, rule on our side? The most important thing is the evidence. The most important thing is the standard that the court reviews, which is a preponderance of the evidence. So the most paperwork that you can have, the most, pediatrician appointments, anything that you have that can show why it is that this move is in the best interest of the child. Employment offers, school records, psychological evaluation, expert testimony. What is it that we can put together that shows that this is what is in the children's best interest? And when we talk about witnesses, we're talking about teachers, doctors, family members who have personal and demonstrable knowledge of how it is you are with the children and what is the new location. Anyone who can speak to their own experience about your time with the children is someone that your attorney should at least talk to in order to determine whether that person can be a witness for you. And that brings us to what are we doing when we actually get to court? I'm not going to read the whole slide, but you need to, representation is a wheel. Your attorney can only push it so far until you have to push back. Your attorney can't create the entire argument for you. We need your help. I always tell my clients, I only have a snapshot of your life, right? You're living your life. You're there with your children every day, whether you're physically with them or not. As a parent myself, I know that we think about our children 24 hours a day. As your attorney, I can't do that for every single one of my clients, and I can't do it for you personally, but you're there with them every single day. You know what they need. You know what is going on. So keep the factors in mind that courts will consider and use that to help create clear and logical arguments that go through that. Judges, I hope there are none on the call, but judges hate doing their job. Judges hate having to do a trial and go through all of these factors and make these kinds of decisions. So make it as easy as possible. When you're putting together your case, put it together using the factors that a judge has to consider. Don't, jump from one aspect to another and, hope that the judge pieces it together for you. Anytime we're making an argument, always, as I've said 100 times already, frame it in terms of what is in the children's best interests. Why is it that this move, Why is it that this school, why is it that this doctor, why is it that this family member, this support system, why is this in the children's best interests? Whether we're talking about moving them or arguing against a move, why is it that this way is in the children's best interests? Always identify, potential weaknesses in your own case and be as honest with yourself as you can be. One of the things that I always ask my clients, when I first meet them and then again throughout the case is, even if the other side is lying, what is it that they're going to say about you that is about you or your family or your location? Even if they're lying, what is it that they're going to say that we need to argue against? Because that's you, again, you live your life. I'm not living your life. Your attorney isn't living your life. So you know better and you know best of what it is that we have to fight against. One of the most important things that I've actually seen courts talk about is offer alternative visitation schedules and communication methods. Again, unless we're talking about someone, an opposing party who is, an alcoholic, a drug addict, an abuser, if we're just talking about a regular person, judges want as much visitation as possible for both parents. They don't want one parent to never see their child again. Nobody wants that. So if you have a visitation method that is better than, a couple of weeks in the summer and a couple of long vacations during the school year, if you have something better than that and communication methods that work better than that, and you are showing that you understand your obligation as the primary residential caretaker of the children, you understand that one of your responsibilities is making sure that the other parent gets time with the children, then courts will take that into consideration and they will say, well, this parent is clearly trying, whereas the other parent is not. And this parent is clearly showing that they have considered the children's need in having two parents who care and love for them involved in their lives, and they are doing everything they can to make sure that both parents are involved. Put yourself in the shoes of the other parent. It's easy to think about, well, I got a job offer in Albuquerque and that's better for me, and what's better for me is necessarily better for my child. Think about what the other parent is going to be seeing when, you're proposing a move across the country like that. Think about the time that they're going to be losing with the child, and definitely put yourself in the shoes of your child and think about all the ways in which the child's life is going to be changed, both positively and negatively, when such a move happens. And just make sure, again, that you're focusing on how the relocation will maintain or enhance the child's life, the child's stability. If we can talk about continuity of education, medical treatment. I actually had one case pretty recently where after all of the testimony was done, the judge turns to one party and says, when does school start in this jurisdiction? And that one party was able to answer. And the judge turned to the other party and said, when does school start in your proposed jurisdiction? And they didn't know. And the judge is absolutely going to take that into account, right? We didn't know about how we were going to have continuity for the children's education. And that is, and that was at the very end of the case, at the, close of testimony. And it's probably the lasting image that the judge is taking in terms of making a decision. One of the other factors that always comes into play is the financial concerns, right? When we're talking about visitation from, one end of the country to the other, we're talking about paying a lot of money, whether it's driving or flying. These prices are sadly not getting cheaper. So how is it that visitation's even going to happen? Is it financially impossible? And if it's financially impossible, that is something that a judge is going to consider when trying to figure out if it makes any sense to move the children from one jurisdiction to another. These ones are they're pretty universal. They're things that I always try to tell my clients when we go into court. Obviously always look presentable and calm. I love telling the story of when I started out as a young attorney. I was doing criminal defense and I was representing a 16-year-old young man on a DWI, and he walked into court wearing a red Budweiser t-shirt. And I had to immediately send him to the bathroom. I said, you turn that shirt inside out, because a judge is allowed to look at you and a judge is allowed to make a decision based on your demeanor and your actions. Obviously, I don't expect any of my clients now as adults with their own children to show up to court in a Budweiser t-shirt, but look as presentable as you can. And when when the attorneys are making their arguments and when the judge is making their statements, I know, trust me, I know as your attorney knows they're lying a lot of times. Or if they're not lying, they're twisting the truth or they're embellishing on things. We know that. We know that because we live with your case as much as we can. You can't sit there and roll your eyes and throw up your hands and gesticulate wildly and things like that, because judges will see that and will make a determination of who you are as a person based on their tiny snapshots of the 15 to 30 minutes that they see you in a various court appearance. The same is true of if you're ever asked to speak in a court appearance. Even if you feel the case hasn't been going your way, you can't let that show through your voice. One of the things that I always have to tell people is nothing changes from one court appearance to another. Decisions aren't really being made in one pretrial conference where one party says, oh, they never let me see the kid. And a lot of times judges will listen to that, but they're not making decisions based on that. So not every one of those side comments needs to be responded to. Common questions that I hear before I get to your questions, if there are any. What if the parties agree to one parent moving, but then the other parent changes their mind? I always tell people everyone is entitled to change their mind, unless and until you get that kind of an agreement in writing, signed and notarized. And even then, if something changes, people are allowed to change their minds. If I can, of course, your attorney can, of course, use the fact that an agreement happened as evidence at a trial, but it is not determinative. It's not the smoking gun that you were hoping it was. It is something that can be used. It is a factor that can be considered that, they agreed to the move up until, a week before moving day, and that's when they changed their mind. Well, if they change their mind for a reason, they are entitled to have that reason heard by a judge. What if one parent moved without the permission of the other? Now, this is a very serious question. If one parent moves and takes the children with them without permission, it's not kidnapping, because it's not criminal kidnapping. You can't be criminally charged for kidnapping your own child. But it is something that judges will absolutely take into account. And that's something that you need to talk to an attorney right away for, and get something filed in the family court and get an order directing that the children be returned. If one parent moves without permission, whether or not it's been discussed, right? If that the other parent has a job offer and they're going to take that job, and they just up and move and they take the children with them, even though you've been discussing it but never agreed, that is something that a court can look at and can say that parent is per se not joint custody material. Per se, these children have to be moved back until we can figure out what's really going on. What if one parent moved but didn't take the children, would like to come and get them now? That's sort of the middle of the road, right? The best would be to make a decision, have something done from the court before you move. The worst would be to just move and take the children with you and figure out the fallout later. This is sort of the middle of the road, and probably is one of the most common situations that we see, because again, you can't work out your move with, taking family court into consideration, right? I can't, get a job offer somewhere across the country and say, well, I need to think about it for the next, 8 to 12 months while I work out a custody battle. They're not going to hold that job open for me. So in that situation, all of the factors have to be taken into account. And the best advice that I could give you is to work out on your own as best you can what visitation is going to look like when you move. So as long as you're consistent and trying to see the children and showing that you're not just going to disappear from the children's lives, that's something that works in favor if you later on down the road want to say, well, while I moved, I found, schools and medical facilities that work for these children that work really well. And I think that they would be better, and here are the reasons why. The response to that would be, well, you moved and for 7 months we didn't hear from you. The children never heard you, saw you, spoke to you. So do your best to maintain what, no matter which side of that you're on, do your best to maintain consistent contact. Where can I go to get more of my questions answered? Right here. On the very next slide, we're going to have, our contact information. Give us a call, set up a time to meet with us. Reach out to us. I'm happy to meet with you and talk to you about all of these things, to discuss everything with you regarding custody and visitation, and, specifically with regard to moving from one jurisdiction to another. Okay, so I guess the question is, did we get any questions coming in, Taylor?
Yes, we did. I will send those over now.
So the first question comes in, what rights does a parent have who is not relocating? That's an excellent question. And it comes down to, there's sort of two sides of that coin. The first is, if the parent who is not relocating was the primary residential parent, then that parent has a bit of the upper hand in terms of saying, well, I'm the one primarily caring for these children on a day-to-day basis. The other parent sees them, I call it the 1950s visitation, right? Wednesdays and every other weekend. If the other parent has that type of visitation, then they can't really say that they're the ones, that they're caring for these children. So what rights do you have? You have the same rights no matter what, whether it's if it's joint legal or sole legal custody. Those rights don't change just because one parent is relocating. It is always best, when you know that the other parent is relocating, to get into family court and have those questions answered by a judge as soon as possible, because taking it into your own hands is fraught with danger, and doing things outside of a court order is liable to lead you somewhere where you're doing things that a judge is going to view negatively. So if you are a parent who is, in a joint custodial relationship and the other parent is moving, get into family court and get an order that says that, the children remain in your county, and, the other parent has to make the argument to try and move them. If you are the non-custodial parent and you have less visitation than the other side, and the other side is the one attempting to move, again, your rights are similar. In New York State, the party moving bears the burden of proving that the move is in the children's best interest. Now, do they have a slight edge? Of course, right? Any parent who already has more time with the child is going to have a slight edge in terms of trying to get all of this done. But if your visitation is such that you consistently are a part of these children's lives, and you've been in touch with the doctors and you've been in touch with the educators, these children, you have, they have bedrooms in your house, things like that. If you can already show that you could be the person primarily caring for these children, then the presumption might switch back to keeping them in the current jurisdiction. For the most part, one of the factors that judges try to always take into consideration when we're talking about the best interests of the children is, how can we keep things as consistent as possible for the children? And if you're able to, even if the other party is the one with primary visitation, if you're able to show, look, I can keep them in the current school district that they're in, I can keep them close to their friends, I can keep them in their current pediatrician, then those are factors that a judge is going to take into account. The next question is, can you specifically define custodial and non-custodial when custody is 50-50 and there is no primary placement? So that's a very specific question. Generally speaking, at that point, if we're talking about visitation, neither of you is the primary custodial parent. However, for purposes of child support, the party who earns more money is defined as the non-custodial parent. Again, that only affects child support. When we're talking about arguments of relocation and custody and visitation, neither parent gets sort of the edge that I was talking about before of being called the person who's primarily caring for the children. That's when you start getting into and talking about, what it is you actually do with the children, how it is you actually spend the time. Does one parent just pawn the kids off on the babysitter or the grandparents all of the time, or things like that. But when there's actually a true 50-50 and there's no primary placement, then courts are going to look to the other factors that we discussed when we talk about relocation. What distance is considered relocation? That's an excellent question. What if a parent moves 50 or 60 miles away? If we're talking about specifically 50 or 60 miles, it starts coming into play more when we're talking about the burden on visitation. So one of the factors, of course, that a court's going to consider is, are we changing school districts? Are we, do we necessarily have to change medical providers if that's, something that's important? When we're talking about changing school districts, that's when we start having to touch on these. But that actually brings up one of my bigger issues with family court as a whole, which is, at the end of the day, all a judge actually needs to review is what is in the children's best interest. So unless you can make the argument that 50 or 60 miles away, which you certainly can in some cases, is going to be a heavy burden on visitation, a court might not even need to touch the the Tropea factors that we went into in this presentation. A court can just say, it's in the best interest of the children to move, and that's, the ruling that a court's going to make. You can always make all of those arguments, though. So it's kind of an amorphous situation, and it's up to the discretion of the judge. But generally speaking, what they're going to look at is the relocation going to burden visitation? For some people, 50 or 60 miles is barely an hour's drive. For some people, 50 or 60 miles is, a 2-hour to 3-hour, trip. So that's going to be, it's going to depend very heavily on your jurisdiction, and it's going to depend very heavily on, how it affects visitation and how it affects the children. And then the next question, presuming a stable relationship between the non-custodial parent and the child, does the relocating parent have a realistic opportunity to relocate the child purely on the financial aspects of the new location? Do we have to find special circumstances for the child that are only available in the new location? To answer the second question first, we do not have to find special circumstances, but if there are special circumstances, that is definitely something that is helpful for the purpose of relocation. For the question of realistic opportunity, I wish I had an answer for that. You find someone with an answer for that, that's one of the best attorneys in the world. Every judge is going to be different. Every judge in every jurisdiction is going to give you a different answer for what it is they think is the most important. The most important thing is to have a clear and logical argument supporting what it is you're trying to do, in this case, relocation. Follow all of the factors as best you can. That's the best way that you have to put together a realistic chance to move. If we're talking about just the financial aspects, if that's really truly the only difference, then they have to be massive. And even then, I have seen judges say that it's not fair that one parent, worked harder and got a better job, and you can't buy your way to more time with the children. So it's not, it's one of the more annoying aspects of our practice that judges are not always going to be super consistent in what they think is important and how much weight they give to specific factors. I would say that if the financial aspect is the number one difference, you and your attorney can work together to find how that affects the other factors, right? There's interplay between all of these, right? You can have a better and more stable living situation if you have more money. You can have a better school district if you have more money. You can have, better extracurricular options if you have more money. You can have better access to medical care if you have more money. So those are the kinds of things that you would want to look into and you would want to discuss with your attorney in order to go through and make sure that all of your arguments are going to be presented in the best possible way. I hope that gave a solid answer to everything. I'm told that there are no other questions, and I've kept you guys here for 50 minutes. So I'm all set. I wanted to thank everybody for taking the time to listen to what I had to say. And those of you who asked questions, I wanted to thank you for taking the time to ask your questions. Please reach out to us, even if you just have questions about your specific case, even if you're not actually looking into moving, but you're thinking about it. It's always better to get answers to those questions before you make any decisions. So thank you all and have a very nice day.
I just wanted to reiterate and thank everyone for joining, and thank you, Daniel, for presenting. Today's webinar was recorded and a copy will be sent to all attendees. I hope everyone has a good rest of their day, and thank you again.